Hello and welcome to the Micklin Law Group's monthly webinar series. Just as a quick introduction before I jump into it, I am attempting to share my webcam, and I don't know how that plays out on the screen. So if for some reason that changes the layout or the slides, I do apologize. I just know I like webinars better when I see the person speaking. So without further ado, let's jump into 6 tips on how to avoid and overcome false allegations in domestic violence cases in New Jersey. As you know, domestic violence allegations can be serious and unfounded. It's crucial to know how to protect yourself if you're facing these circumstances. In this webinar, I'm going to provide 6 tips to help you navigate these difficult waters. Before we begin, for those that haven't worked with me, this is me. My name is Brad Micklin, the lead attorney, managing member of the Micklin Law Group. We're a law firm concentrating in empowering men and fathers in divorce, custody, and family law matters, with offices in Nutley, Montclair, and Saddlebrook, New Jersey. I'm putting up a slide now, series of awards and accolades I was previously honored to have received. Different organizations, different groups. Some are personal, client-based awards. Others were based on colleague recommendations. I put this up not to impress people, but to impress upon you the work and the network that I am a part of. I'm also called upon various times from national news organizations as a legal commentary. I've been on Fox News, Inside Edition, Larry King, may he rest in peace now, I-24 International News, and various others. Again, not to impress, but to give an idea of my experience so that you can trust in the information that I'm about to provide for you. What is domestic violence? Defining domestic violence encompasses a range of behaviors, including physical, emotional, financial, and sexual abuse. It can also include controlling or manipulative behavior, stalking, and harassment. And I apologize if the slide is actually providing duplicate information. It wasn't when I created it. It's new technology, so at its mercy, as I often am for technology. So the thing about domestic violence to understand at this stage is the acts that are complained of mirror a criminal statute and similar conduct. So the acts that can be utilized to claim an allegation of domestic violence is homicide, assault, terroristic threats, kidnapping, criminal restraint, false imprisonment, sexual assault, criminal sexual conduct, lewdness, criminal mischief, burglary, criminal trespass, harassment, and stalking. And the last 2, harassment, stalking, and I guess terroristic threats, are the most common utilized. They're important to understand and to review, and I'll talk about that a little later in this webinar, how to prepare yourself. But you want to understand the acts if you're not going to have an attorney, because everyone has a specific intent, a specific act that needs to have been accomplished with a specific purpose. Like harassment has to be just not annoying, but having to intended to actually harass, which can be a difficult thing to establish. Terroristic threats has to be something that could have reasonably caused fear of it being accomplished. Like, for instance, you make a terroristic threat to kill somebody, but you're nowhere near them, and it's over the phone, it's questionable whether or not it actually would have terrorized that person, for instance. So understanding the basis is crucial at this stage in your preparation. What it looks like. Domestic violence can take many forms, subtle psychological bullying to physical abuse and even homicide. It's a pattern of behavior that one person uses to exert power and control over another in a relationship. And it's important to understand, as well as with the next slide of information, that it's not always the person alleging the act of domestic violence that is the victim. More often than not, I shouldn't say more often than not, but quite often, the person making the allegations of domestic violence is actually the abuser and either has psychological or emotional issues and is alleging domestic violence for their own personal reason. Sometimes they're incapable of understanding that their abuse is actually abusive and they're not the victims. And there's countless other reasons why you may get an inaccurate or a false restraining order alleged against you. And the intent of this webinar is not just to address if it's a fraudulent or false restraining order, but whether or not the allegations may be true doesn't necessarily mean it rises to the level of being domestic violence. And that's an important distinction to understand because, and I hope to have in the description of this webinar, another one I did about how to prepare to defend against a bogus restraining order. Uniquely different. If the restraining order, and we'll talk a little more thoroughly about this, but the restraining order has to provide two things: an act of domestic violence and the need for permanent protection. So whether or not you may have created an act or committed an act of domestic violence doesn't necessarily mean that it rises to the level of needing permanent protection, and vice versa. Whether you did something that needed permanent protection doesn't necessarily mean it rises to being an act of domestic violence. So the two components of both need to be present, whether or not the allegations are true. So lastly, on the slide before you, the impact of domestic violence can be traumatic for those who experience it. It can lead to physical injury, emotional trauma, long-term health effects. It can be difficult to overcome, but it is possible with the right tools and resources. Just stopped it and started the recording, so I hope it doesn't cause a second recording, because I see again typos in this page, which I apologize for. So the impact of domestic violence obviously is significant and long-term. Again, I always often take the position of being on the defending side because I do men's and fathers' rights, and I believe, I'm not certain, but I believe it's more often filed by women against men. Reasons I won't get into because they're too voluminous. Certainly available to answer questions at the end of this or at a separate consultation. But if you are the defendant, doesn't mean you're not a victim of domestic violence. As I mentioned, quite often they're being alleged by people that, and it's false or inaccurate or misleading. They may be committing acts of domestic violence themselves. You may be the victim or the perpetrator or both. Additionally, the impact is often not just on the person alleging it. It can be the children of the relationship that are present. It can be other family members that may be aware of it or also get involved in it. So it's a widespread issue. It doesn't just impact the two people that are involved in a restraining order trial. Common false allegations of domestic violence. Accusations may arise as a result of the partner's ill feeling towards you, fueled by bitterness and revenge. It can be manipulation. They may file a false claim under the influence of others to get what they want, such as custody of children or financial gain. Misinterpretation. Behavior can be taken the wrong way, leading to exaggerated or false claims by the accuser. And as I mentioned earlier, mental health issues. Many accusers suffer from mental health disorders, such as borderline personality disorder or schizophrenia, can contribute to false allegations. I'm not here to purport to be a psychologist or psychiatrist. I don't opine on people's mental states and what causes or doesn't cause conduct, but I have been doing this for over 20-something years. I have also published many webinars and books and blog posts on certain mental health issues to the extent they are involved in family law and divorce matters. I've done a significant amount of work on narcissist and borderline personality disorders. Again, I have separate webinars that you can watch on those issues specifically, but in my experience, to put in its most simple form, the most common false allegations I see are people trying to get leverage in divorce and or custody cases, or when they're both. It is very effective because it's very swift. Almost anybody can get a restraining order against almost anybody by making up egregious accusations. While the statutes do require it be certain individuals, certain types of relationships, that definition, the definition of relationships, and what type of relationships qualify, have been greatly expanded over the years. And because they're often being obtained late at night, on weekends, on holidays, they're being obtained by people who, in the process, like police officers, municipal court judges, who may, in certain circumstances, not have the time to dive into it. They may be in the middle of a night's sleep, celebrating a holiday, who knows? And there's usually a preference to err on the side of caution as opposed to clarity, meaning they won't dive, judges and the police officers won't dive deep into allegations to see whether or not it rises to the level or it's the appropriate relationship. They will more often grant them than not, which is very problematic because it rewards bad behavior. People who abuse the system to obtain restraining orders will learn that that conduct works and do it in the future. It often does give great leverage because it will, for instance, give possession of the residence. It will give custody of the children. And like I think we're going to talk about later, it's supposed to be because it returns a hearing in, say, 10 days stacked by the statute, but that almost never happens now, especially post-COVID backlogs and quarantine effects on our system. And when it starts, it doesn't often conclude for a very long time. I've had cases and clients who've had months without their children simply because of a bogus allegation. And it's unconscionable, but it's very swift and very severe, and it's rigid, so it's hard to change until it's over. Know your rights and seek legal help. And I don't say that because I'm an attorney. I say that because it's very challenging to handle these matters without proper legal advice. First, know your rights. It's essential to know your rights if you're facing domestic violence allegations, especially if they're untrue. An attorney can help you navigate the legal system and ensure you're not taken advantage of. Two, reach out for help. There are many organizations and resources that can help guide you if you're facing false allegations of domestic violence. And you don't have to do this, and you shouldn't do it by yourself. Lastly, and again, retain legal representation. A skilled attorney can help you build a defense, document evidence, and communicate effectively without difficulty. I know my slide says with law enforcement, but it's more important for court. So along the lines of knowing your rights, one of the most important things to know about is that you can file a cross complaint, and you probably should. Of course, it must be meritorious. I'm not just saying go out and file something because you have a complaint against you. But in my experience, most of the time, if this allegation of domestic violence is untrue, that person who's filing that false restraining order has probably committed acts of domestic violence against the person who he or she's filing against. So that person, being the person I'm speaking to now, you, would be able to file a cross complaint. It is very effective because, first of all, it gives you a chance to be and voice your problems with being a victim of domestic violence. Also, levels the playing field a great deal when you talk about whether it's going to be dismissed or a civil restraining order, which I won't go into at length, but I do have webinars on those. It certainly helps you a great deal, so you're not just going in defending yourself. There's also an appeal process once for the temporary order that gets issued. You can go to the Superior Court judge and appeal the entry of the restraining order before its return date. You can file an appeal of the decisions like the custody award or the residence that are granted in a temporary restraining order, and anything else that may have been ordered that you think is erroneous. In my experience, judges are not inclined to grant appeals primarily because they're first issued by different judges, which complicates another judge changing it in the short term. But it also goes to the mentality of better safe than sorry. Let's make sure everybody's protected and get to the truth later. It's not an approach that I favor, and I think many people that are defendants in bogus restraining orders suffer a great deal because of that mentality. But nonetheless, it's what you're facing. Additionally, realize that you are supposed to have a return date in the trial within 10 days. They are now usually in person, and this is being recorded October of 2023, post-COVID quarantines, post what should have been the backlogs from it. But in my experience, you don't get a trial in 10 days. Usually you get the first listing in 10 days, and that's often virtual. Check the orders and call the court to make sure. And from there, it gets scheduled. It can be scheduled usually a week or two later. If there's attorneys, it almost always is adjourned from the first hearing, so you're not, again, going to go forward in 10 days. And once you start, it's not going to last 10 days. And that's important if you're going to take my advice about filing a cross complaint or an appeal, because while it may seem simpler to just move forward and try to get rid of the complaint facing you, it may be lasting for a very long time, and you may forfeit your rights to file a cross complaint or an appeal if you don't. And then if you expect it to be over in 10 days and it's over in 3 months, you're going to regret those choices. So fourth, next, get an attorney, at least consult with an attorney, find out what advice they have to offer you. You can get some steps as to what you need to do. If you can't afford to bring one to the trial, it can be very expensive. And again, if it goes months and so hearing dates, it will be very expensive. But you want to know how to prepare. You want to know what to expect. You want to find out if there's going to be a criminal case that could follow, because it's a separate court system and a different burden. Restraining orders are family matters, but quite often criminal complaints do issue following them. You want to understand what the presumption of sole custody is in regards to a final restraining order. You want to understand the repercussions of having one issued against you. It will, again, aside from the custody presumption I just mentioned, there will be travel restrictions, potential criminal cases, like I mentioned, potential future contempt charges in family court for this restraining order. So it's not just this one hearing that you need to worry about. And that's why you desperately need to get legal advice. You want to also know about the discovery or the exchange of information. Typically in domestic violence cases, there is none, but considering the process has now become one that is much more elongated than it has historically been, more judges are allowing the exchange of information, which will definitely help you prepare your defense. And you want to know about amending restraining orders once they are issued, whether it's the one against you or the one that you filed as a cross complaint. First, most of the time they are improperly completed because they're done by court staff or police officers. They're done, like I said, at night, on holidays. Most of the information that's needed does not go in there. It used to be you had to amend it prior to the date of trial and serve it. Then the law developed that if it was amended during the trial, it could be adjourned so you could prepare a defense. Now I've been having judges say that it can be pretty much amended at any time during trial. So whether it's the first day, it used to be the first day you could get the amended trial or amended restraining order and get an adjournment to prepare your defense. Now you can go through an entire trial, and at the conclusion of the plaintiff, the person who filed the case, they bring in new allegations, and judges have been recently allowing it in, saying that it can be amended up until the very last moment of trial, which is horrible because you're preparing the whole time based on the allegations you know of, based on the allegations that are being set forth in court, and all of a sudden out of left field comes new allegations you didn't know anything about. Now you have more time, more delay. If you are out of the house and are without your children, that's going to continue. But it's currently the process. Like I said, the ability to do so is getting greatly expanded in my experience. But if you happen to have a cross complaint, knowing that is also going to be helpful because you can do the same thing, and you should do the same thing because it's provided. And if you don't bring it up in an amendment, you can't mention it at court, and you can't rely on it. Documenting evidence and establishing an alibi. Document your activities. Document your whereabouts, conversations, and other relevant data and details to establish a consistent pattern of behavior. Keep records of text messages, emails, social media posts, and phone calls. Yours and theirs. However, inside of this, because you have to know, and I think we touch on this somewhere later in here, you cannot have any contact with the person who files a restraining order against you, at least while the order is in place. So I usually recommend people go into their social medias and take the other person off of any accounts, as well as any joint, not joint accounts, but like connected people. Like, you may have children together, and your children's accounts will have the other parent. And when you're putting messages up there, not only are you possibly having contact with them, at least indirectly, but the statements you'll be making could later be utilized or claimed to have been violations of the order, intended to harass. So go and take those down. But as far as your conduct, your behavior, your text messages, you want to keep copies of them. You cannot delete any posts, cannot delete any evidence. It's actually criminal. So, but you want to go back and see what documents you have for when you were, places where you were. You can print out text messages. And I'll get to that in 1 minute with regard to documenting evidence. But first, let's talk a little bit about the alibi, being mindful of timestamps. Pay attention to timestamps on any documents, including receipts, photos, and witness statements. It can help establish an alibi and provide a clear picture of your activity at the time of the alleged incident. Along that line, also look at things that are newer information that may not have always been available, like metadata on your photographs. You take a picture on an iPhone, it will show you when and where. Unfortunately, I don't know anything other than the iPhones because that's what I use, but I have to imagine other phones have similar information. Computer IP addresses are becoming more prevalent in court because they're easier to obtain. 10, 15 years ago, computer companies never released IP addresses and emails and things like that, but now you can get that, so you can show where you were, where information was coming from, whether it was in fact your computer, your IP address, whether or not the picture is accurate. And keep in mind, as artificial intelligence is creeping quickly into this, people will believe information to be accurate and documents to be truthful, but there's a significant ability to now tamper and modify information. You can take a picture and remove the person from one picture and place it into another. So for instance, if you have a picture of your spouse, at a restaurant, you can take that and change it so that that person's now in a bar and provide it as evidence. So obviously that's fraudulent, but you have to be aware that people have this ability now, and judges aren't usually that technologically savvy because they're not using it. They're not using technology day to day. They're not following the developments of artificial intelligence. So you need to understand it better. You may need to have an expert come in to understand it. But be aware of it and be prepared to examine whatever is being offered as far as timestamps and text messages and social media posts and the like. And lastly, with regard to this documenting evidence, get witness statements. If possible, get statements from people who may have witnessed the alleged incident or could provide additional information. Credible witnesses who support you can go a long way in helping you prove your case. Keep in mind, first though, getting a statement from somebody is not admissible at the trial, absent extenuating circumstances, but generally speaking, they're not admissible. You want to get the statement so that you know that they're on your side, and you want it to be, if you can, in writing, possibly even notarized, but you can't use that notarized statement in court unless that person comes and lies. You can impeach them with it, but you get the statement so you know what they're going to say. If you want them to testify favorably, they have to be there. If you need to get them there and you can't, then you have to have a subpoena issued. Another reason for needing an attorney to represent you. So, in regard to this, of course, you want to get an attorney. This information, like I just mentioned, even just a cursory review, is voluminous and complicated, very difficult to handle on your own. You want to know, if you're not going to have an attorney, rules of admissibility, not just for the witness statements that I mentioned, but also for your timestamps, for your text messages, for your emails, social media posts. There are rules and guidelines for how this information and when it is admitted. If you have to use it, you need to understand how to get it into court. You want to know what the rules of what's called hearsay. Relying on information other people said outside of court is complicated, but very important in many cases. It's a complex rule with a lot of exceptions, but you need to know them or have somebody like an attorney who knows them at the trial with you. Avoiding contact with the accuser, which I touched on briefly. First, get a restraining order. As I said, that in this context, it's usually a cross complaint. Document any attempts at contact. The accuser attempts to contact you. Document the interactions. Keep a log of the date and times, contents of the conversations, and any other relevant details. 3, don't fall into traps. Be mindful of situations where the accuser may try to bait you into an argument or physical altercation. Stay calm and avoid any situation where the confrontation is likely to occur. And you can take steps if you're facing false allegations, and even if you're facing what may be true allegations, you can protect yourself by obtaining the cross complaint that prevents them from contacting you or showing up at your place of work. Now, generally speaking, also, a person who obtains a restraining order against you is not allowed to have contact with you. They can't come and put you in violation of an order. If you happen to be in a supermarket, they can't enter the supermarket and then say that you have to leave because you're not supposed to be there. But if you see them there, you have to leave. If it's involuntary or unintentional, then you have to leave. If they try to contact you, you cannot take the call. If they text message you, you cannot respond. But you want to document that they did it. It'll go a long way to showing they're not afraid for their safety, which is a crucial part of a restraining order. But also understand that absent this kind of context, you cannot have any contact with them. Often people will not understand the nature of the restraining order, and because they're more often than not a very close, intimate relationship, they're not accustomed to being prevented from any contact. So they'll pick up the phone or send a text message like, "Why did you do this to me?" Or "How could you say this? It's not true." And it's a violation. And a violation is a violation. It's criminal. So don't do it. Again, I hate to sound like a broken record. As soon as you're served with one, cut off all the contact, block their numbers, close their social media accounts, contact an attorney. Building a support network and maintaining emotional well-being. Talk to a professional, not just an attorney. Dealing with false allegations of domestic violence can be emotionally taxing. Consider speaking with a therapist or counselor to help you manage your stress and emotions. Usually these individuals cannot testify, so you can feel confident in discussing and relying on their support. Lean on friends and family members. Having a strong support network can make a big difference when dealing with false allegations of domestic violence. Seek the counsel and support of friends and family who you trust, as well as those who may be able to support you in trial. And lastly, focus on your well-being. Don't let the allegations consume your life. Engage in activities that you enjoy, promote your well-being, such as the hobbies that you may have engaged in before or exercising regularly. Don't let it consume your life and become obsessive over it. You need to have good, well balance. If you follow the advice of the other slides and the other steps, hopefully you will be able to maintain a level head while you're facing these types of allegations. So in conclusion, false allegations of domestic violence can be daunting, but with the right tools and resources, it's certainly possible to overcome these circumstances. Take the necessary steps to protect yourself. Don't be afraid to seek the counsel of legal mental health professionals during this difficult time. Now, I'm just going to leave this up. I won't read the legal disclaimer, but I'll leave it up for a minute so you can review it. I do hope this information helps you if you are unfortunately on the receiving end of a restraining order. And again, remember, it's not whether it can be a false one, it can be in part a valid one. The advice doesn't change because not simply, but by committing an act of domestic violence doesn't mean that you are to receive a final one. And if you do receive a final one, you certainly want to understand what that means and its impact on you. You can always contact the Micklin Law Group if you need assistance with a family law matter in New Jersey. Our website is micklinlawgroup.com. It's MICKLINLAWGRUP.com. Our phone number is 973-562-0100. And as I said, we have a YouTube page, Brad Micklin, MICKLIN, with a wealth of information and videos for you, as well as many on our website. The website's the best place to start because there are fewer but more relevant and important videos. YouTube is much more robust, has many others, and obviously an easier search, but there's so much more there. It's sometimes harder to narrow to get exactly what you're looking for. So start with the website, then go to the YouTube page. Thank you, and I wish you all good luck.